So, a Chapter 7 bankruptcy can be a very stressful event for the debtor. As already mentioned on this page, the debtor is already in financial difficulty. They're probably getting phone calls and letters, some of which could be very harassing from their creditors, and essentially you're at the end of their rope. So, when they meet with an attorney, they are often frazzled, often stressed out. Sometimes they're a little ashamed that they're even seeking bankruptcy protection. So, one of the first things an attorney should do is help put the debtor at ease and let the debtor know, or let's call them a client for these purposes. Let the client know the benefits of a bankruptcy, that it is not a scary or shameful proceeding, and let them know what to expect if they decide to file. So after that initial consultation, at which time the attorney should let the client know what their fee is, and the going rate for Chapter 7 bankruptcies in Central Florida is between $1,500 to $2,000. If an attorney charges too much more than that, they may need to justify it to the trustee or the bankruptcy court judge. But assuming that the client decides to retain the attorney, pay the fee, the next step is for the client to assemble their financial documents. This is a massive undertaking. It usually requires going back several years in the client's records to find old bank statements, old bills, tax returns, etc., etc. I do hope that you took a look at the schedules and the statement of financial affairs and the means test that I posted. This gives you an idea of just some of the documentation that's necessary in a bankruptcy, and it is very extensive. This can be very, very difficult for some clients, but it is a step that cannot be passed over. The failure to provide a complete bankruptcy, a complete and accurate and honest bankruptcy record to the court can lead to charges of bankruptcy fraud against both the debtor and their attorney. So it's very important that the client does produce all of the financial records. Then the attorney or their paralegal, and bankruptcy is a very paralegal intensive field of law, will take that financial information and plug it into the correct forms and the correct format that the bankruptcy court wants. During this time, the debtor should also be taking a credit counseling course. They'll have to take 2 courses during the bankruptcy, and one of them does have to be completed before the bankruptcy can even be filed. But once it's filed and the petition and the schedules and the other documents are ready to go, they will be e-filed by the attorney with the bankruptcy court. After that, the debtor will have to attend their 341 hearing, and within a few weeks or a few months of that, the debtor should receive their discharge of all dischargeable debts. Now, you have read a little bit about how some debts, such as student loans, alimony, child support, are not dischargeable. But as long as it is one of the vast majority of debts that is dischargeable, the debtor is at that point completely released from any obligation. Now, it's important to note the debt does not go away. It's just the debtor is no longer responsible. So for example, imagine the debtor had a car loan which they co-signed with, say, their mother. The debtor's obligation to pay that car loan has gone away, but not their mother's. The debt remains, just the debtor's obligation is gone. And that is something that needs to be discussed with debtors by their attorney. So that's basically what the debtor goes through in a Chapter 7, and please continue reading because in the next few pages we talk a little bit more about exemptions, which are assets that the debtor can expect to keep even if they file a Chapter 7 bankruptcy. And this can be, of course, very important to a debtor. They do want to know that they will have something to their name even after they complete a Chapter 7 bankruptcy.